Hello everybody, Happy New Year! It's a beautiful day today here in Great Neck, and I thought I'd share some great information with you. It's a wonderful day, so let's get right to the title that I asked in this video. What can happen to a doctor who alters your medical records in a lawsuit that you have brought against the doctor for medical malpractice? You want to know what can happen? I'll tell you right off the bat. The doctor can lose his license to practice medicine. Now, why would the doctor ever risk losing his license to practice medicine by altering his medical records? Well, the only time that really occurs is if the doctor is trying to hide something. If the doctor is trying to show that he did nothing wrong, and now, in an attempt to do that, knowing that there's a medical malpractice case coming, or a case is already underway, a doctor who tries to alter their medical records, hey, nice to see you, Happy New Year. A doctor who tries to alter their medical records might actually be successful, and the patient may never actually learn that the doctor altered those records. But there are some instances, and you should know this does happen from time to time, there are some instances where a doctor has altered their medical records, and we have been able to prove, can you believe that? We've been able to prove that the doctor actually altered those records. So let me give you an example so that it highlights exactly what can happen and how it can happen. All right, so let's say that you're unhappy with your doctor's care and treatment, and now you decide to go to doctor number 2. In preparation for going to doctor number 2, you want a copy of your medical records. So within a few days of leaving your doctor, you request a copy of your medical records and now get them from the office and decide to go to doctor number 2. Doctor number 2 goes ahead and starts treating you. During the course of your treatment, you believe that doctor number 1 did something wrong. So now you search for an attorney. Your attorney goes ahead and requests a copy of your medical records from your original doctor. You happen to have gotten a copy of your records as well from doctor number 1 and had brought them to doctor number 2. So you go ahead and get those records as well. And now you compare those records. Those records are markedly different. They totally contrast for those same exact dates of treatment that you had. And you're wondering, how is that possible? How could the doctor have 2 different sets of records? Well, I'll tell you how. Because with the first set of records, that's right, Happy New Year from New Jersey. Hey, Mike. The first set of records, the doctor did not anticipate that you were going to be bringing a lawsuit, right? So now his office staff went ahead and copied those records, gave them to you so that you could go ahead and bring them to doctor number 2. Fine. But now when an attorney goes ahead and requests copies of the records, now this doctor might have gotten concerned that you might be thinking of a lawsuit. Hey, Jonathan, nice to see you. Happy New Year. He might be concerned and, for whatever reason, might have decided to materially alter your records. And now, in response, he gives copies of those records to your attorney, not realizing that his staff had already given you a copy of your records to give to doctor number 2. They didn't make a notation of that. So he didn't know that you had already obtained a copy of your original records. So in that instance where you have clearly 2 different sets of records, now we are able to show that yes, this doctor altered his medical records, and if we're able to do that, there's the potential that the doctor could lose his license to practice medicine. And because that is such a significant deterrent, most doctors are not going to want to go ahead and do that. Rather, they'd simply live with whatever repercussions occur from whatever wrongdoing they may have done, because they were careless. And now their insurance company will defend their case, and they'll go ahead and go through that litigation process. But some doctors turn around and say, you know what? No. I'm gonna prevent this from happening. I'm gonna alter my records so there's no evidence of showing that I did anything wrong. Let me give you a great example of an instance of a case that I handled for another law firm where I was able to show conclusively that the doctor altered his medical records. And this was remarkable. All right, so here's the scenario. A law firm that I know asked me to go ahead and do a deposition, which is a question and answer session of a doctor whom they had sued in a client's lawsuit in a medical malpractice case. And in preparation for doing that, I went ahead and reviewed the entire file, along with the doctor's medical records that the client had obtained when they had gone to doctor number 2. And based upon that information, those were the records that had been provided to the medical expert who had reviewed their case and confirmed that they did in fact have a valid basis for a case. Okay, so now I'm prepared to go forward, and this is an interesting case. It had to do with a failure to diagnose cancer. And the doctor had claimed that in this scenario, he had told and recommended that the patient undergo certain treatment based upon this diagnosis. For whatever reason, the patient said, hey, the doctor never told me I should do the following things, and because of that, I had delayed treatment for my cancer and now caused it to spread. And I'm thinking, how is that possible? How could the doctor actually make a diagnosis and not tell the patient what treatment they actually need? That makes no sense whatsoever. And my thinking at the very beginning was, there's no way this is really a valid case. And that was what I was thinking as I'm going through the medical records, even though a medical expert had confirmed that there really was a valid basis. Okay, so one of the things that I did that morning, right before we actually started the deposition, was I asked the doctor's attorney for a copy. Actually, I asked to see the doctor's original records. And that's something that I will always do at the beginning of a deposition. Why? Because I want to go through the doctor's records to see what's there. I want to go through his chart to make sure he's brought all of his records with him, including his billing records. I want to see if there are any notations that are in his chart that he made or that are in there that are different or significantly different than the copy that we have obtained, usually from the very beginning of the case. All right, so in this particular instance, when I asked to see the doctor's original medical records, I'm going through page by page, and now it's taking me just a few minutes to go through, and I noticed something remarkable. I noticed that these records are totally different than the records that I reviewed the days before leading up to this deposition. And I'm thinking in my mind, how is this possible? How could the doctor have altered all of these records? It's for the same exact dates of treatment, but the notes are markedly different and they say totally different things. So, what did I do? I quietly closed the doctor's file, handed it back to the attorney, and I began questioning the doctor. Now, since these were the records that the doctor claimed were his own original records, I used those records to question him. And based upon those records, it would appear the doctor did nothing wrong. It would appear that the doctor's own records indicated, yes, I spoke to the patient, I told the patient what to do, I gave her the diagnosis, and according to those notes, this doctor did everything correctly. And I even asked him, I said, doctor, based upon this information, would you agree that that conforms with good and accepted medical practice? He said, absolutely. And would you agree that a patient who was not told about needing the following treatment in light of this diagnosis, that would be a departure from good care, wouldn't it? Oh, absolutely, correct. But as you see in my notes, it clearly indicates that I did tell the patient. What I was doing was locking this doctor into his testimony to show and establish that all of his testimony was based upon the records that he provided. What he didn't know was that we had a copy of his original records. Now, what did I do? I continued the deposition using the doctor's own records that he brought to this deposition. At the end, after I was done asking him about all of his records, I pull out our copy of the records. And then what happened? Oh my God. Okay, you're going to love this. I said, doctor, I'm going to show you a set of records, and I want to ask you a question. You see these records? Yes, I do. They're photocopies. You see that? Yes. In fact, they are faxed copies. This is all in your handwriting, isn't that? Yes. And doctor, you are the only one who made notes on this patient's record, isn't that true? Yes. And the records that I have here are in your handwriting and for this particular patient, correct? Yes. Not only are they for this particular patient, but for the same exact treatment dates that this patient was seen in your office, isn't that true? Yes. And his attorney didn't get it yet. And the doctor was just beginning to realize what it was that he was looking at. I said, doctor, I have the faxed copies. Where are the originals? He said, I don't know. I said, doctor, do you know that this set of records was obtained by my client only days after leaving your office? No, I didn't know that. Doctor, can you explain to me? And we went through each and every page. Doctor, You saw that this patient was seen on this date? Yes. Let's take a look at the record that you brought with you, okay? And now we compared them side by side. I said, doctor, you see that these records are materially different, correct? Yes. Can you tell me why they're different? And you should have just seen the look on this doctor's face. It was like the deer in the headlights look. It was like, and finally his attorney got it and realized that this doctor had altered his medical records. So, this case would have likely been defensible had the doctor not altered his medical records. But in this particular instance, I was able to show that this doctor did in fact clearly alter his medical records. And what can happen to him? Well, if the attorney pushed it or the case went to trial, there's a good likelihood that this would have been going to the New York State Department of Health, and the doctor likely would have lost his license to practice medicine. Because here it was intentional that the doctor tried to hide the evidence of what he did, or more importantly, what he did not do, that caused the patient's cancer to actually advance and get much worse. So why do I share this quick information with you? I share this with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize that you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, it's a beautiful day today here in Great Neck, and truly, I ask you, I invite you to pick up the phone and call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.